You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. Different motions, and I want to address those motions with you. If you want to come to the podium, since you are representing yourself, first of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of a prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself, so I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action, and so there are videos from the officers in the jail at that time, and that's going to be one of the largest problems in providing that to him.
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and that was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc, he'll access it as he needs to at the jail.
Okay.
All right, when is this going to be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first. I still ain't got a motion yet.
A motion?
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today, because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. We'll have it within.
Ben, she should have it today.
We'll have it within 10 days. You have a second motion, which is a motion to remove your counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself. You don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things, that's the reason that you have elbow counsel. Why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant. For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
Well, that's part of life, that people have illnesses and sickness. I am going.
Not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule.
I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available, and for that reason, I believe that complies with the request for speedy trial that was filed. It is the first available date that we can put into play. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk, so that motion is denied. In addition to that, you had a motion to recuse the court recorder. Again, I have no idea why. I don't find any basis for removal or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts, and a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded, but...
Well, we wasn't on break because, look, I just walked out the courtroom and I said something after we went on break. You said omitted. And she said, well, I ain't got to omit it. She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
Well, first of all, I don't recall any such thing that
Well, go back and look at the video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will address
I'm familiar with all the rules. Y'all sit me in jail long enough, best believe I read them.
All right. Anything else?
No, that's all.
All right. Thank you.
Briefly, if I may, when would Mr. Vaughn be transported up for this trial? Because the trial that
I
I
done
mentioned...
put in 3 motions for that. That ain't get heard neither.
I'm just asking the court, because The trial that I have in Davidson County that I mentioned in the earlier matter is the first of that week. We do not expect that to be a 5-day trial. I'm wondering if I'd be able to meet with him to strategize at all for this trial beforehand, other than Thursday, the 18th.
We can have him, we can order that he be transported earlier if you just tell me when you want. The
I think-
17th?
No, I like my cigarettes where I'm at. I don't need his assistance.
Okay, well, that'd be fine, Your Honor.
That's fine with us.
Yes, sir.
All right, thank you, Mr. Vaughn.